Welcome to EPG Pathshala. This paper is the Philosophy of Law. The current module is entitled Habermas's Between Facts and Norms. The objectives of this module are to understand this book, Between Facts and Norms, written by the German legal philosopher Jürgen Habermas. This module was written by Mesam Badamchi from the Sehir University of Istanbul. I am Akash Singh Rathore from Lewis University of Rome. Jürgen Habermas's book, Between Facts and Norms, Contributions to a Discourse Theory of Law and Democracy, was published in English in 1996. Since the publication or the reception of this work, many have hailed it as possibly one of the most important works in legal philosophy in the 20th century, and certainly a work that is completely in line with the great German intellectual tradition on legal theory, going from Kant to Hegel to Weber. So the book is highly regarded as pioneering both the 20th century philosophy of law as such and as fitting very firmly in a great Germanic tradition. But the interesting thing about this is that it is a peculiarly hybrid kind of work. So there are so many disciplines that are woven into Habermas's overall argument, from sociology and the sociology of law, to philosophy and the philosophy of law, to democratic theory, political philosophy, political theory, and other similar disciplines from the social sciences and humanities. Habermas, the author, manages to weave together all of these interdisciplinary studies into one great work on the theory of law, in line with his earlier, broader philosophy, the theory of communicative action. So the discourse ethics and the theory of communicative action of Habermas is now supplemented by a profound philosophy of law that, like his other philosophical works, weaves together the most important work from his own tradition, the German tradition, in those many disciplines: sociology, philosophy, legal studies, and so on. Another interesting aspect of this book is that it not only is interdisciplinary, but it's one of the first books to successfully integrate the Anglo-American tradition of jurisprudence into the European tradition of jurisprudence. So what we've had for many centuries is a distinction between the common law systems of the Anglo-American world and the civil law systems of continental Europe. What Habermas has attempted to do in this book is to integrate them both within a larger theoretical framework in this amazing book, Habermas's Between Facts and Norms. This module will discuss the way that Habermas completes this task. Let's begin with Habermas's intellectual biography. Habermas was born in Düsseldorf, Germany, that's West Germany, in 1922. After he graduated from high school, he studied at the universities in Göttingen, Zurich, and Bonn, and he obtained a doctorate in philosophy, writing his dissertation on the German Romantic philosopher Friedrich Schelling. After a 2-year period working as a freelance journalist, Habermas restarted his academic career by joining the Institute for Social Research. Now, the Institute for Social Research was originally founded in the 1920s and is known to us commonly as the Frankfurt School. That is, that this is a school that unites or brings together a different group of social sciences and philosophers who are all united by working in the tradition of Karl Marx's. This institution was shut down by the German Gestapo, or the Nazis, in the 1930s, but it reopened in 1951. So Habermas was able to join it, and in doing so, he enters a community that is represented by amazing social and political and psychoanalytic philosophers like Max Horkheimer, Theodor Adorno, Erich Fromm, Herbert Marcuse, and many others. The first generation of critical theorists was followed by a younger generation of scholars, among whom Habermas became a key figure. So Habermas more or less represents the second generation of the Frankfurt School. While in Frankfurt, Habermas worked on a book that was regarded as his first very important work. It's called The Structural Transformation of the Public Sphere. Now, this remains one of Habermas's best-known works in democratic theory, and Habermas argues for the role of the democratic public sphere in the development of modern Western societies. The work is basically founded on an empirical sociological approach, where Habermas traces the 18th century development of a bourgeois public sphere, in which political and cultural debates occurred in face-to-face meetings at cafes and coffee houses, and through the medium of print. However, during the 20th century, the critical potential of the public sphere gradually faded away as a result of its commercialization into a mass society of public opinion. So you can see this idea of the mass society as representing some of the basic ideas of the Frankfurt School. To use the terminology of Habermas adopted later, the modern life world was colonized by money and power. Well, the theme of democracy that is central to the structural transformation of the public sphere stayed with Habermas throughout his career, also having a significant place in his book that we are discussing on the facts and norms, his legal philosophy. After 2 years of teaching at Marburg and Heidelberg, Habermas returned to Frankfurt as a professor of philosophy and sociology. Now, it was in this period that Habermas started a research group on legal philosophy and legal studies and ended up writing Between Facts and Norms. As suggested in the title, Between Facts and Norms attempts to mediate the tension between empirical facticity, in German that's called Faktizität, and abstract validity, in German that's called Geltung. Now, this Geltung is being translated as norm. Habermas discusses contemporary expressions of each of these aspects of legal theory from both the German and the Anglo-American traditions. On the one side of the spectrum lies the norm-dismissing, factually fixated functional approaches to legal studies represented in people like Max Weber and Carl Schmitt, both of whom we discuss in other modules in this paper. Whereas on the other side, there are the empirically blind, normative outlooks of other legal and political philosophers, such as Kant or Rawls. Kant and Rawls are also discussed in other modules in this paper. Now, what Habermas does in Between Facts and Norms is he criticizes both of these positions. So, on the one hand, Weber and Schmitt for being too empirical-oriented, on the other hand, Kant and Rawls for being too norm-oriented. The sociological theories of law, according to Habermas, convey a false realism that underestimates the normative presuppositions of existing legal practice, while the latter philosophical theories of justice are mostly problematic in their formulation, unaware as they are of social reality and the realm of empirical facts. Habermas's theory of law can be understood as proposing a solution to the insufficiencies of both of these intellectual poles by interpreting law in terms of theories of communicative action and discourse ethics. The project of Between Facts and Norms can be partly regarded as an attempt to inject a normative dimension into the legal sociology of Weber and Schmitt, who assume that even a law imposed by force, even by a force that is irrational, as long as it's observed by a population, can be considered as valid and legitimate. Since Between Facts and Norms follow Habermas's earlier work on communicative action, it will be useful to devote some time to explain some of the basic tenets of his theory of communicative action, and this is what we will do now in the next section. The theory of communicative action was originally published in German in 1981 in 2 volumes, and then it was later published in English in 1984 and 1987. It had a huge influence on philosophy in the late 80s and early 90s. In these books, Habermas begins the exposition of his theory by postulating the problem of the rationality of action as the central subject matter in the theory of sociology, which goes all the way back to classical sociological scholars like Weber. Habermas identifies 2 concepts of rationality. One is cognitive instrumental rationality, which concerns a conduct that is oriented towards a successful realization of certain goals. So this is the instrumental. The second is a communicative rationality, which is applicable to interactions in which the actors are oriented towards mutual understanding. So this is something more innovative. This communicative action is a representation of rationality that is mutual oriented. Habermas argues that these 2 forms of rationality must be understood as ideal types variably applicable to different social structures. Habermas considers it an exclusive characteristic of human interactions that they are symbolically mediated on the basis of the use of language through speech. Being concerned with the claims implied by the actual use of language or speech acts among persons which they are oriented towards reaching understanding, Habermas suggests that the actual use of language or speech acts inevitably imply claims on three different levels. So let's discuss what Habermas is talking about. Every speech act will function or be oriented towards understanding, and it will do so in three levels. The first level is a claim that the speech act is true as corresponding to a state of affairs. The second level is the claim that the speech act is right with respect to a specified normative context. And the third is the claim that the speech act is expressed sincerely. So we can talk about truth, rightness, and sincerity in any articulation or speech. Habermas refers to this order of communication as discourse and thereby differentiates the theoretical discourse concerning truth from the practical discourse on rightness, from the expressive or evaluative discourse concerning authenticity and sincerity. So what this suggests is that speech acts take place within a given context, which Habermas refers to in German as the Lebenswelt. That's translated in English as the life world. Following the German phenomenologists like Husserl, the concept of life world is defined as referring to the combination of cultural values, social norms, and socialization patterns that often remain unquestioned among actors and that enable interactions to occur. Specifically, Habermas has in mind the economic system of capitalism and the political system of the bureaucratic state in Western societies, which function on the basis of money and power. So, for Habermas, this cognitive instrumental action is occurring within that economic and political system. He contends that social problems arise when the life world is interrupted by a society's money power system, so that communicative actions are redefined in instrumental terms. So all of this description sounds very complicated, but the fact is that Habermas is basically saying something quite simple and sensible. On the one hand, anytime we communicate either in order to convey a truth, to convey something that is right, morally accurate, or just to express something. And we can communicate in two different ways, either instrumentally, in order to get something out of the communication, or in some way sympathetically, in order to mutually understand one another better. And what happens is that in the life world being colonized by money and power, or in other words, in capitalism taking over our social system, what happens is that all of our communication starts to be attracted towards an instrumental political economic form of discourse rather than the mutual understanding that is part and parcel of the very nature of communication. So if these are some of the main points from the theory of communicative action, let's discuss how he proceeds into between facts and norms, because as we've stated in the introduction, between facts and norms is very firmly grounded in the German intellectual legal tradition from Kant to Weber. Now we've seen some of the critiques of both Kant and Weber in the way that Habermas doesn't want to discuss the Weberian empirical position, and he doesn't want to be fixated upon the Kantian normative position. But the influence of Kant on Habermas is very clear. So let's see how Habermas takes up ideas of Kant's philosophy of law in his own work. In Habermas's view of law, Kant brings out the tensions between facts and norms, or between facticity and validity, as Habermas puts it. Kant grounds the legitimacy of law in a universal principle of right, what in German is called Rechtsprinzip. And this is the condition under which it's possible for a morally oriented subject to universalize the limits on behavior. For Kant, law is the sum of those conditions under which the free choice of one person can be conjoined with the free choice of another in accordance with the universal law of freedom. This is a very interesting definition of law. The sum of conditions under which the free choice of one person can be conjoined with the free choice of another person in accordance with a universal law of freedom. So he wants freedom to be included within the definition of law, even though we normally consider law to be a constraint upon our freedom. This analysis of law represents the internal tension between facts and norms, which is emphasized by Habermas. As enforced, law demonstrates social facts, demarcating areas where strategy-oriented individuals can choose and act as they wish. But, as linked with universalizable freedom, law deserves the respect of moral persons and thus carries a claim to legitimacy. The tension between facts and norms can be interpreted as Kant's inability to overcome the tension between private and public autonomies in Kant's theory of constitutionalism. So Habermas inherits a great deal from Kant, but he also thinks that the way that Kant differentiates between private and public autonomy creates a problem or a tension in the attempt to harmonize between facts and norms. For Kant, the notion of private autonomy is almost synonymous with morality or natural rights, while public autonomy or collective self-determination is identified with the idea of the social contract. However, Habermas argues, insofar as Kant's argument for the establishment of civil society or the state relies solely on the universal principles of right, public autonomy is subordinated to a moral principle or private autonomy. Doing so violates the legitimacy of law because it removes law from the process of democratic lawmaking and it excludes the right to subjective liberty or any relation to collective self-determination. As we're going to see in the next section, Kant's argument fails to reconcile the private and the public autonomies of citizens. And this is a task that Habermas sets himself in between facts and norms, which is reconciling the private and the public autonomies of citizens under one comprehensive and legitimate legal regime. So let's move on now to this reconciliation between liberalism and republicanism, in other words, reconciliation between private and public autonomy. By arguing for internal relations between private and public autonomy, Habermas's book, Between Facts and Norms, provides an alternative to both the liberal and the republican models of legal legitimacy. The liberal models of sovereignty, which derive from John Locke, emphasize the impersonal rule of law and the protection of individual freedom. This model views the democratic process as constrained by and in the service of personal rights, which guarantee individuals the freedom to pursue their own goals. On the other hand, the tradition of civic republicanism, which stems all the way back from Plato, later reshaped by the work of Rousseau, is an approach that Habermas also thinks is slightly wrong. This approach gives priority to the democratic process as a collective deliberation that ideally leads citizens to reach agreement on the common good of the state. On Republican view, human freedom has its peak not in the pursuit of private preferences, but in achieving collective self-governance through political participation. Republicans tend to ground the legitimacy of law in notions of popular sovereignty, whereas liberals tend to define legitimate government in relation to the protection of individual liberty and human rights. So what we're seeing over and over again is that Habermas in this book is pointing out the two dominant traditions and the ways in which they both exaggerate a certain aspect and failed to address another essential aspect of law and the idea of rationality that adheres in law. So whether he puts this between facts and norms, between empirical and ideal, between liberal and republican, in every case, Habermas is trying to find a middle ground that has more virtue than either of the two alternative positions that he's arguing against. We see that again with his work on Rawls. So in Between Facts and Norms, Habermas also addresses Rawls's work quite in detail. To deal with the insufficiencies of both liberal and republican models, and remember that Rawls's model is a liberal model, Habermas centers his account of legal legitimacy on a discourse principle. This is how he puts it, and I quote, Only those norms are valid to which all affected persons could agree as participants in rational discourses. So this sounds very much like a social contract through a liberal lens, a Rawlsian lens. Now, this discourse principle reminds us of Rawls's principle of legitimacy in political liberalism. According to Rawls, our exercise of political power is proper and fully justifiable only when it is exercised in accordance with a constitution, the essentials of which all citizens may reasonably be expected to endorse in the light of principles and ideals acceptable to them as reasonable and rational. By anchoring the legitimacy of law in the democratic discourse principle, Habermas avoids both the moralist or the classical liberal interpretation of law and the later favoring of private autonomy in the form of human rights, and also the Republican interpretation of law and its favoring of public autonomy in the form of collective self-determination. So what we see here is that Habermas is attempting to reconcile public and private autonomy, reconcile facts and norms, or reconcile Weber and Rawls. So let's move on to the category of rights that Habermas discusses in Between Facts and Norms. For Habermas, the internal relation between private and public autonomy requires a set of abstract rights that citizens must recognize if they want to regulate their life together by means of a legitimate positive law. These rights fall into 5 broad categories, which Habermas lays out in Between Facts and Norms. So you see that these rights serve to reconcile the private and the public. They serve to reconcile the Weberian and the Kantian, and they serve to reconcile the liberal and the Republican. So this is the innovation of Habermas's position, is that he's always finding ways of reconciling the different camps. The 5 rights serve to do that. The first 3 are the basic negative liberties, membership rights and due process rights, that together guarantee individual freedom of choice, and thus they guarantee private autonomy. The 4th are the rights of political participation. These guarantee public autonomy. Each side is vital and cannot simply be reduced to the other. Without the first 3 sets of rights, there's no private autonomy. Without the 4th right, there are no laws or rights guaranteeing that private autonomy, and just impose it as a paternalistic imposition rather than as a manifestation of self-governance. Now finally, the 5th set of rights are the social welfare rights. These become necessary insofar as the effective exercise of civil and political rights, and you can basically see the first 4 sets of rights as political and civil rights. These rights depend on certain social and material conditions of welfare so that citizens can meet their basic material needs and enjoy their freedom. So what Habermas has done is he's set up a framework of rights that allows him to reconcile all of the different dualisms or different positions that are represented in the history of the philosophy of law in the German tradition. As I had mentioned, the Frankfurt School is all united by their orientation in a post-Marxist vein. Habermas is one of the first in the Frankfurt School, the foremost figure of the second generation, to start to leave the Marxist elements somewhat behind. For example, you can see from this module that Habermas's theory of law that he presents is very different from the Marxist theory of law that we had discussed in an earlier module. The Marxist theory of law is vaguely implemented in Habermas's notion, but it's certainly Habermas's idea of law has moved well beyond the Marxist conception. After discussing the interdisciplinary nature and the way that Habermas's work arose from his work in the Frankfurt School, we went on to discuss the way that Habermas's book negotiates between several rival positions, so represented in the title itself, between facts and norms, between the empirical camp and the normative camp, between the Weberian notion of a very positivistic law and the Rawlsian notion of a highly normative understanding of law. So Habermas's position served to integrate, in some respects, both facts and norms by integrating the role of empirical positive law and normative or axiological conceptions of the nature of the law. Habermas did this first by discussing Kant, which we discussed briefly, and we see that in Habermas's work he owes a great debt to Kant's philosophy of law. But he also pointed out that the problem of the public and private in Kant bleeds into Kant's philosophy of law, so that public autonomy and private autonomy are not reconcilable in Kant's framework. Habermas attempts, through his book, to surpass this framework and ultimately to reconcile public and private autonomy. In the process of reconciling public and private autonomy, Habermas also reconciles the legal and philosophical traditions of republicanism, civic republicanism, and liberalism, both classical liberalism and the contemporary variant in John Rawls. So the goal of Habermas's book is to weave together all of these different disciplines, to bring out everything he has learned from the profound German tradition of the philosophy of law, to include the elements of Marxist critical thought that are valuable for a robust contemporary philosophy of law, and to negotiate between continental and Anglo-American theories or traditions of law to come up with a legal theory that both depends upon and further articulates his own discourse theory and his very famous first theory of communicative action. Thank you.